and welcome to Stowe Talks, a podcast designed to support anyone going through a relationship breakdown and all of the challenges that this brings. I'm Matthew Taylor.
And I'm Liza Gatchell, family lawyers at Stowe Family Law. And today we're joined by Singh Basi, an award-winning barrister at 4PB in London, who's here to talk about children in the family court. So welcome to Stowe Talks, Manny. It's really lovely to have you with us today. Do you want to just start by introducing yourself to our listeners?
Yeah, firstly, thank you so much for having me on Stowe Talks. And yeah, so I'm a barrister based primarily in London, but I work all across England. I specialise in family law disputes, mainly in respect of children, but basically everything and anything family law related. And I was called to the bar, I think it was 2014. I've been in London ever since, but I'm not originally from London. I'm from the Midlands. Yeah, that's who I am and what I do.
Well, it's great to have you with us today. So the purpose of today is to kind of give for our listeners a guide to, children in the family court, as the title says. So we're looking at primarily, I guess, children at proceedings, and there's obviously the two areas of that, private law and public law. So perhaps we'll talk about that, and then other areas, including, I guess, things like surrogacy and adoption. So it's a really wide area. I mean, I think the first thing to acknowledge is that when a lot of clients, a lot of people going through a separation hear about family court and hear about their children getting involved in the family court, there's probably a sense of dread. It sounds like a really, really scary thing. So hopefully we're going to, it's not something that you want to go in with joy in your heart necessarily, but hopefully give people a bit of reassurance that it doesn't have to be like that, and that, about how to navigate the system better. So, perhaps we can start with just a real basic question. When we're dealing with children, what's the function of the family court? What's the purpose of, family court proceedings when children are involved, Manny?
Yeah, so I think that's a great question, because ultimately I think the function of the family court is to resolve disputes that people caught up in the proceedings just can't resolve between themselves. And I think that's a really important aspect, because I think generally when you enter into the court arena, the goal and the aim is to just have disputes resolved, and that can be resolved by agreement between the parties. But where that cannot be achieved, and sadly that unfortunately is the case, for many different types of family law disputes, you have no choice at times for the court, whether that's a judge or a magistrate in certain proceedings, to have to resolve those issues for the benefit of the children who are unfortunately, again, caught up in those proceedings.
I think resolving disputes is really key. And I think there's certain things that I often say to clients that the family court can do and is good at doing, and certain things that it can't do. So what it's really good at doing is providing a framework, making determinations sometimes about binary issues, which school to go to, providing a framework for people to parent their child, what day is a child with which parent. But what it can't do, and what is really difficult, and what often a lot of time clients want, understandably, is to effect kind of behaviour change. So, if their ex-partner is behaving in a certain way, to change that. And, what do you see in that? Because it's kind of a subtle distinction sometimes. I wonder if, do you agree with my assessment in terms of what the court can do and perhaps isn't so good at doing, or isn't set up to do?
Yeah, no, I completely agree with you, that people don't always necessarily change, and sometimes bad behaviours or actions may come under the scrutiny of the family court, depending upon the issues that the case has to deal with. But what I would say is court process generally, and whilst it's there to resolve disputes, it's obviously very difficult for those who are caught up in the proceedings and those who have to try and navigate it, whether it's through lawyers or by themselves. And I think nobody necessarily wants to be in the court system or have to resort to the court resolving their issues. So I do think it's a very good opportunity in that sense, that when there are issues, and issues have to be, and I emphasise on the word have to be, resolved in the court system, once they are resolved, hopefully that enables those people caught up in those proceedings to not want to be caught into that process again. They can learn a lot through that particular experience. And yes, whilst they might not be able to change, and there might be other issues still lingering about, which has resulted in disputes in the first place, hopefully those issues just do not materialise again in the future.
It was really interesting a minute ago. You were talking about, you kind of just dropped in that sometimes the decisions can be made by magistrates and sometimes they can be made by judges. And I think it'd be really helpful because actually, I think some people don't quite understand why their case has been put before a magistrate or why they just assume that they're getting a judge. And often this is because they've been watching the television, predominantly American television, and that's the kind of courtroom that they're expecting, if you like. So could you just set out sort of the differences between those, between magistrates and judges and kind of what people can expect?
Yeah, of course. So I think how it starts off with is through the gatekeeping process, basically behind the scenes. So how proceedings initiate. If we deal with private disputes, which are disputes between, let's say, parents in respect of a child, relating to the upbringing, as Matt emphasised earlier, it could be a schooling issue, or it could be contact, or it could be a name change or something like that. That initiates through what we call a C100 application. And that application has so many different boxes, so many different sections that people have to fill in. But that information is very important because the complexity of the case can be ascertained through that. So firstly, what is it you're seeking and why are you seeking? Whatever. Has there been any other significant involvement with authorities or any other risk factors that exist? All these are questions, I think, in the C100. And so what happens is when that is issued with the local court, they have a gatekeeping service. I think, although I can't be entirely sure, it may be a legal advisor, who I'll come on to later on what they are, who will go through that process. And they will allocate the case depending upon the complexity. So certain types of cases are very complex and they have to go to a judge, or it could be a specific level of judge, or they might not be complex in that sense, or do not fall within the certain criteria, and they can go before magistrates. And I'll give a couple of examples, but I'll explain the difference. So magistrates are essentially, we call them lay justices. They are volunteers. I don't believe they get paid for their services. They are volunteers within the community. And they either sit as a group of 3 or a group of 2 minimum, and they deal with hearings both in public and private law. But if we focus on private very briefly, and they are assisted by a legal advisor who is often a trained lawyer who is there to guide the magistrates on law only, but the decisions are of that of the magistrates. You then have 2 types of judges in the family court: district judges and circuit judges. And circuit judges are basically a senior level of a judge, and district judges are the less senior, but also a very important level of judge. However, in terms of the issues they deal with, it varies a lot. So, for example, if I give an example, if somebody wants to take a child on holiday to a country, what we call a non-Hague country, which is a complicated terminology, but just dealing with that, because of the complications that arise when dealing with that specific welfare question, the matter might have to be allocated to a circuit judge. Other disputes may be allocated to a district judge, other disputes, magistrates. Typically, and I think more common for people, is you have your standard disputes dealt with by the magistrates. But just to emphasise, that will never be at the first hearing. There's more than one hearing, but in terms of allocation, it would normally start with the magistrates. And I think I should also emphasise that sometimes gatekeeping is not always that effective, because complexity can not really arise until the first hearing. And so whilst you might be allocated to the magistrates at the beginning, it may be reallocated to a district judge or circuit judge thereafter, depending on the issues of the case. And there's so much. But in short, there is guidance on the allocation of cases in both public and private law proceedings. And the gatekeeper is the one that will look at the application and try to apply that in respect of what the issues are.
So you've mentioned public and private law, and something I floated at the start. So these are 2 distinctions that might not be apparent to a lot of people. So maybe you could unpack that for a little bit. What makes a public case and what makes a private case?
Private, as I say, will be disputes in respect of parents relating to the upbringing of a child or children. So that can be, as you say, change of school, change of name, surname. It might be relocation. So you could be living as a family, even though the parents are separated. The children could be living in Manchester, and the mother may have a job offer in Newcastle, for example, and may need to go to Newcastle with the child and needs the court to approve that relocation, or even a relocation to another country, for example. So any disputes relating to the upbringing of a child or children that requires a decision in line with their welfare, in line with the best interests of the children caught up in the proceedings.
So they're effectively, really trite reductive terms, but that's like mum v dad, isn't it?
Yeah.
There is a dispute between mum and dad, or mum and mum in a same-sex parenting, and there's a dispute between them that they can't resolve, but there's no other bodies or agencies involved that are getting into that. So that's what makes it a private dispute.
Yeah, and that's what makes it private. And right at the outset of proceedings, you will have a form of CAFCAS involvement, which I think we may come on to, what we call a safeguarding letter that tries to assist in resolving the issues. And then we have, I completely agree with that. And then we have public law disputes. Now, these are often regarded as more serious in nature. And the reason being is because it's state intervention. It's essentially social services or the local authority who are asking the court for a particular order to safeguard the children and or child caught up in those proceedings. So in those types of cases, you will have the local authority, you will have the mum, the dad, you will also have a guardian appointed for the children as well. And essentially that could be through various things. There could be certain assistance that's what the family require that has to be enshrined within a court order, so the court approves a certain form of action. Or it could be this lots of serious issues going on and issues relating to care order, interim care orders and interim supervision orders, where the local authority are given power, particularly an interim care order where they've got parental responsibility to exercise as well. And so they're the two distinct areas, I would say, of family law when it comes to the standard type of cases.
So we've talked about kind of what happens when you complete your application, you submit it to the court, it goes through gatekeeping, how it will be appointed to different levels of judges. And then interestingly, you said there will be a first hearing. It won't conclude at that hearing. I think that's really important because certainly for clients who have, they've done all the right things. So they've been to mediation before, they've issued their application, they've tried solicitor negotiation, they cannot agree, they issue their application, they get a court date and they're like, right, that's it. That's my end date. That's when a decision is going to be made. Can you go through with us why a decision is not made at that hearing, what that hearing is, and then kind of what the different hearings are that they might experience?
Yeah, of course. So the first hearing I called Fahadra. I know everyone else calls it different pronunciations.
We love an incomprehensible acronym in family law. Yeah.
Yes, first hearing dispute resolution appointment. So in short, the focus of the first hearing is to essentially look at the issues in existence and to try and resolve if possible. But how it normally works in practice is, what you've got to remember is cases are often about evidence. Cases are often about you putting forward your case. But at the first hearing, there's a limited opportunity for all the issues to be addressed that can be identified, but may not necessarily be addressed. And that's because how proceedings initiate is through a application, a C100. There's not necessarily a statement. So what I mean by that, there's not actually like detail from the applicant saying why they want XYZ or why they have issues about XYZ. So what you have during that process is, before the hearing, you have CAFCAS in private law disputes. And this is always the case with CAFCAS. I know there's various pilots and things going on around England that I'm not entirely familiar with yet, but the standard process is CAFCAS will contact the parents subject to the application in advance of the first hearing. And CAFCAS have a very important role because they're there to identify issues and to provide recommendations for the court, and more importantly, to identify any safeguarding issues. And how they do that is they have sight of the application and they also speak to both parents. They ask questions about mental health, allegations of harm, domestic abuse, etc. They also have access to local authority checks and police checks, so that can form part of the letter, which I'll come on to. And then they will summarise the position of both parties, what they said to the CAFCAS officer. And then there'll be a heading at the bottom, recommendations for the court. So this letter could be 2 pages, it could be 3 pages. It's called a safeguarding letter. But in short, it's a very important letter because CAFCAS, who deal with cases all the time and are qualified social workers, they are able to identify, they have that skill set to identify and understand safeguarding issues and what the court really needs to do to either determine those issues or to have regard to those issues, or whether further information is required. And so you rock up to the first hearing and the court will have that safeguarding letter. That is basically the template. And the safeguarding letter could say things like, I would ask that the parents file statements addressing X, Y, Z. I will ask whether I think the court may benefit from a letter from the GP because mental health issues have been raised or the ability to care for a child has been raised. But more importantly, when it comes to domestic abuse, what we call PD12J, the Family Procedure Rules, has a particular process when we look at domestic abuse and how that is considered and how that is determined to be relevant to the application. And CAFCAS will outline what their initial views are in the case. But at the first hearing, because there's no evidence on the parties, and often they might not always get that safeguarding letter well in advance of the hearing, it might be a few days before, it might be a couple of weeks before, the evidence just isn't there. So if there's lawyers at the first hearing, there will often be arguments about case managing the case. What needs to be done? What's agreed with the safeguarding letter? What's not agreed? So, for example, if CAFCAS say there may need to be consideration for a fact-find hearing because serious allegations have been made, and as a consequence of those serious allegations, and in light of the application that is seeking overnight contacts or whatever, there needs to be a determination of those allegations for the court to have a clear factual basis. If that is recommended, what you might not necessarily have at the first hearing is, well, what are the full allegations? What are the full extent of the relevance of those allegations? And so the court may say, look, these are the issues flagged up by CAFCAS. I want to direct both of you to do statements or both of you to address this, and we can have another hearing where we properly case manage the case. However, notwithstanding that, the goal of the FHDRA, the first hearing, is to effectively manage the case generally. And so that's what you have as the first hearing. And then normally you have, for example, let's say there's no fact find, there's no aspect of that, but there's just issues relating to welfare. But the questions relating to welfare are a little bit complicated, where the court may need help from actually CAFCAS. And they might direct CAFCAS to do what we call a Section 7 report, which is a welfare report, basically an investigation into the issues and what the recommendations are from CAFCAS. And if that is directed, the next hearing will be a DRA, a dispute resolution appointment, where the goal is at that hearing, all the evidence is complete, both parents have filed statements, there's a CAFCAS report, or there might not be for a dispute resolution. It doesn't have to always be a CAFCAS report. But the goal is there to identify and resolve, to hopefully settle the case. Ultimately, the final outcome in private law cases is a final hearing. And a final hearing is when there's clearly still disagreements, despite all the evidence, despite potential Section 7 or not. And somebody is not happy with either the recommendation or the position. The application has not essentially been resolved. And as a consequence of that, a judge or magistrates will impose the final order. They will hear potentially evidence from the parents. They will hear potentially from CAFCAS officer involved in the case and make a determination. What I do say is, whilst those are the three main hearings, there's of course fact finds, which can arise rarely at any stage, but normally after the first hearing. There are other hearings such as pre-trial reviews, when the final hearing might be quite complicated, multi-days, and there may need to be a small hearing to just make sure all the evidence and everything is complete. There can also be directions hearings generally. So, for example, further evidence is needed, or there's been a change in something and we need to urgently restore it back to court to get the case back on track. There can even be non-compliance hearings. So there can even be hearings where somebody is just not complying with stuff that the court has required them to do. That could be not getting the medical records. That could be an expert not doing X, Y, Z, or suddenly a need for an expert to do X, Y, Z, or parents not complying with evidence. So there can be lots of little hearings, but the general consensus and the general goal is to try and resolve disputes as quick as possible in line with the welfare of the child, and any delay is prejudicial to welfare in that sense. And so ultimately the goal is to first hearing, identify the issues and then resolve how those issues are going to be dealt with. Second hearing, try and settle and the case, dispute resolution appointment, everything is there. You now can decide. The last hearing, unfortunately, no agreement. Court will impose the outcome on according to the law. So I know that's a very long answer to that question, but I hope that is helpful.
I mean, it's very full answer. I mean, it's hugely helpful, I think, to anyone understanding what can be a complex system and given the various sort of stages that are involved.
I work in the South, so we have the Pathfinder pilot in the South, which has been running since 2022. Is that it has spread out now? Has it reached you yet, Matt?
Yeah, so it was in North Wales as well as a pilot area, and it's gone wider now, so it's started to hit more of the regions.
So it just works slightly differently in that it's more front loaded.
Yeah, and exactly, and that's the thing. So I've personally, in practice, not come across it, but my colleagues have, and I know it's been rolled out and spread out across England, and I think it will continue. That trajectory will continue because, from what I've heard, lots of positive things.
Yeah, I was just having a look before. Actually, the sort of data suggests that the average length of case resolution in Pathfinder areas has dropped from sort of 29 weeks to 18 weeks. So, what you're talking about, the delay being inimical with the welfare of a child, that speaks to that. You want to crack on. So, yes, that's a slightly more front-loaded scheme. And there are various pilots around the country that try and, we're always looking to improve the system, always looking to see where it can be refined, sped up, and make sure that justice is done. I think something that I might be helpful to touch on a little bit, partly if you mentioned numerous times, because we talk about it all the time, the welfare of the child as being the key determining factor. And I think parents are often concerned about how their children get involved in court proceedings.
Yes.
Is my child going to be given evidence and have to be cross-examined? There's various different ways in which the voice of the child can be heard in proceedings. You've talked about CAFCAS and a CAFCAS report. How does the court know what the child thinks, what the child wants to happen, and to what extent is that considered? To what extent is it appropriate for a judge to say, well, the child wants this, therefore we're either going to do it or not do it?
Yeah, no, 100%. I think one really good thing about the law in England is everything is centered around the welfare of a child or children, and their wishes and feelings are one very important aspect of the checklist. So the court considers various things about a child in respect of their welfare, and wishes and feelings is one. But how a child is heard and their role in the proceedings generally is really important. And what I would say is there's three overarching considerations, I would say. So if we deal with the Section 7 report from the outset, because I think that's the main issue, because sometimes if there's no Section 7 report, the court is faced with two parents saying different things, and the child might not necessarily be, their views have been not ascertained at all. But that is usual for a child perhaps who is very, very young and obviously cannot speak, cannot express, because they may be 10 months old or 1 year or 2 years old, but they're very vulnerable in a different sense. So right at the start of proceedings, this is one really important issue for CAFCAS at the outset, because what CAFCAS do is they identify whether the issues in the case would probably warrant what we call a Section 7 welfare report. And it's basically a report from CAFCAS that looks at the welfare and provides recommendations and tests and looks at the evidence in the case and tests some of the issues as part of their role, and then provide detailed recommendations. However, that is not always undertaken by CAFCAS. Section 7 reports can be undertaken by three different things, really. So firstly, you have CAFCAS as an option, who are typically the ones doing the reports. You also can have the local authority. So I mentioned earlier on public law proceedings and state intervention, but there can be at times where the local authority are not getting involved in the family in terms of taking the family to court and dealing with things that way. But the local authority have been tasked to deal with issues before in the life of the child. So, for example, referrals from the school could be made to the local authority, or a parent might make a referral against the other parent and say, look, there's these issues, I think I need the local authority assistance, and the social worker may be allocated. And because of the social worker being involved in the case, pre-litigation, be involved in the family, they have a familiarity with the family. They've already perhaps spoken to the kids or the other child or the children in the case, spoken to the parents, the wider family. And so CAFCAS identify this in the safeguard letter, and they will say, look, here's the local authority checks. This child was subject to certain plans. Local authority have helped this family many times. There should be a Section 7, but the local authority will be best placed doing it because they know the family and things like that. And then lastly, what you have is where people are very much worried about the delay. And I have to emphasize the delays is a downside to getting disputes resolved, because each court, each area of England have different timescales. Even CAFCAS have different timescales wherever. That sometimes parties agree that, look, we actually need a social worker. We need someone really to deal with this issue. CAFCAS themselves say it should be a Section 7. But unfortunately, CAFCAS, because they're so busy, may take 18 weeks, 20 weeks, 22 weeks. But we have an independent social worker who could do it in 12 weeks. The only downside to that is the independent social worker is you have to pay. You don't have to pay CAFCAS. They are involved generally. So you have to pay the fees for the independent social worker. And so those three factors are really important about how children they are involved in the proceedings. Because what I would say is this: with an independent social worker in a standard private law case, you might have more contacts observed. So, for example, where contact is an issue, or the progression of contact between a child and a parent, and you might have an independent social worker who has the resources, time, and availability to observe perhaps more contact, and are able to comment more on what the child says, maybe more meetings with the child. CAFCAS might not be able to do a lot of meetings with the child, and the local authority, again, they've probably had other different considerations when dealing with a child. And so what often happens, typically the best ways in which children are involved is their views are ascertained. What is it they're saying about the issues? Depending upon their age, how they are approached is different. A 6-year-old will be approached different to a 12-year-old. And a social worker, whether that's a local authority, CAFCAS, or independent social worker, has that skill and ability to ascertain views depending upon the age of the child. At times, you can also see children who do letters to the court through the report. So the CAFCAS would do it in their child-friendly way. Do you want to write anything for the judge? Also, CAFCAS, local authority, independent social workers may speak to even other wider agencies. The wider family may speak to the school, where children's views have been expressed elsewhere or through different mechanisms and ways. And you do also have the very complex cases in private law disputes where children are theoretically added as party to the proceedings and they're represented by a guardian. And that arises in a very small range of cases. But a child's wishes and feelings is very, very, very important. And you can imagine why so, because if a child is being asked to potentially envisage moving school, I mean, how that child feels about that is vitally important, or relocating to elsewhere in England. But again, it does depend on the age, and not always wishes and feelings can be properly ascertained, because the child, as I said, maybe 3 or 4 years old and does not really, of course, have that understanding about the impact, about what may or may not happen. But the social worker will look at, or the CAFCAS officer or independent social worker, or if none of them are involved, the judge or the magistrates will still have to apply that welfare checklist.
Children are people pleasers, aren't they? And often it's not a case. But you said at the beginning that you have two parents sat before a judge, both saying, little Tommy told me X, and the other one saying the complete opposite. And that's not necessarily that both parents are lying, and it's not necessarily that the child is lying, but it's more that they ultimately want to please mum and they want to please dad. And there can be problems with parents trying to get too much information out of children during the course of proceedings. I wonder if you've got any advice to somebody that's going through these types of proceedings as to how they communicate with their children about the proceedings themselves, and the things that they can say and the things that they shouldn't be saying.
At the end of the day, the reason why I was interested in family law generally is when I was young was because I think the most important thing or concept in people's lives is their family. That's my personal view. So I fully understand that if two parents are involved in a dispute where everything is centered around a child or the children, that parent or both parents feel a huge level of responsibility to try and make sure that child is shielded and protected. But sometimes parents can feel that other people aren't really seeing the issues and they may go about things their own way. Now, what I would say is, in these types of cases, no one tells people how to parent, but there are many things that can be done which is just not good, or could be perhaps even harmful to a child when they're caught up in proceedings. So each case depends on the particular facts. So, for example, a child who's 14, 15 may be very aware, just through their own knowledge and intellect, that their parents are going to court next week, and they fully are aware that the parents are fighting in court due to issues. How a parent approaches that to how a parent approaches a 7-year-old, of course, will be vastly different. But what I would say to people is, to try and trust the process around them. And what I mean by that is if you have lawyers and you have, say, their solicitor or barrister or whoever, they are professionals. They're not telling you how to parent, but they can tell you they've got wisdom by seeing these cases time after time after time again about what you should really do or what you shouldn't be doing. Likewise with professionals such as Kafka social workers or independent social workers, they are qualified directly to be dealing with children. You've got to kind of respect their views and ways. And same with judges and magistrates who see disputes just like yours day in, day out in court. They also know a lot. And so I fully appreciate that emotions run very high. I mean, one thing I would say is very interesting. 10 minutes before joining this link, I saw that the Family Justice Council just released the guidance on covert recordings, literally just hot off the press. And that is, for example, a very important document, I would say, for everyone to read, because, you know, as you will both know, that over the years, people like record things without the other parent knowing and certain things like that. And that's very much looked down upon. And so what I would say to people is if you do have lawyers or you're getting help through any other, you know, charity or support base, they know the law, they know what's good, what's bad. Just listen to advice firstly. What should be emphasized is also, even if you don't have lawyers, you have the safeguarding letter from CAFCAS right at the beginning of the proceedings, identifying the issues and identifying the recommendations about how the case should progress. And I think people caught up in proceedings can learn a lot even from that letter.
Yeah, I think, I mean, the message of listen to your lawyer is a good one that I would
We'll take
echo. Yeah, we'll take that. if only that were the case. Yeah, I think the CAFCAS letter, you know, it can be a helpful document. It's quite a difficult document for people to read sometimes because there is a bit of he said, she said,
yes.
And that may be accepted, it may be denied. And sometimes the recommendations don't go your way, or they are typically quite cautious recommendations because very understandably, you know, the CAFCAS will want to err on the side of caution and just not rush at things, which is quite proper. But there's a lot of, you know, helpful stuff there. Yeah, I also saw the covert recording stuff land and thought, I wish we had just another hour.
Yeah.
I think I've had to flick through it rather. But there we go. That's for another podcast, I think. So, I mean, but that's some really helpful tips, Manny, about how people can, you know, engage in the system and trust the process, which is a hard thing to do. I don't underestimate that. I mean, what other tips have you got for people if they are about to make an application, they're on the receiving end of an application, they're about to go through court proceedings about their child? I mean, what are your biggest tips for people going through that?
Yeah, what I would say to people going through the proceedings, whether they're on the right side in the sense that they're the ones initiating the proceedings for whatever reason and they're anxious to get that resolved as soon as possible, or whether they're on the other side where they're having to respond to it, is firstly, it doesn't always have to be going through the court. That's what I'll emphasize right at the beginning. There's a tremendous amount of focus on alternative dispute resolution, and that can take various forms. It doesn't even have to be formal. And what I mean by formal is like with a mediator or somebody else, an arbitrator. It can be as simple as having a conversation with the other parent. Look, I understand you made an application. These are the issues. Can we try and resolve it by X, Y, Z? Can we test this? Can we do this? Do you want to go meet for a coffee? And look, let's put the emotions aside and let's have a discussion. And I think that is really important. And I think generally within the system in England, whether it's even financial remedies or children stuff, the growing need and benefits for alternative dispute resolution is one really important thing. But where that is not possible, what I would say, because proceedings are just initiated, you've already caught up in proceedings, alternative dispute resolution can be considered at any stage, a week before the final hearing, a day before. I've had so many cases where I get agreements literally 5 minutes before entering the courtroom. So just remember that court isn't there. It's not. You're not there to fight. You're there for issues to be resolved for a child who you love and the other parent equally loves, and that child equally loves both parents. And so the ability to try and resolve disputes is important. So what I would say to anyone is whether you're the applicant or respondent, just remember you both want what's best for the child caught up in the proceedings. And so there's always a potential you can at any stage resolve the issue. So never shut the door on that. Other than that, I would say what you also have to be prepared for is the process can be long. And I have to be very much honest about that. Again, courts are different in terms of their timescales and listings. But whilst the process is long, you have a voice. And the way that is achieved is you will be addressing the judge if you don't have a lawyer, or your lawyer will be doing that for you. Separately, you will be able to do statements and put forward your case and the evidence you have. So you can be reassured by the fact that CAFCAS and or the judge or the magistrates will have sight of your position in its entirety. And if for whatever reason you're not happy with the recommendation of CAFCAS, as Matt emphasised, or the initial safeguarding letter, that is subject to challenge. There's many occasions with me or other lawyers up and down the country have come to a final hearing where there's a specific recommendation and that's been overturned. That's always a potential as well. So I always think it's very important so two things really, is that you have a voice that should hopefully reassure you that your position can come across. And secondly, at any stage, you can iron out these issues, and it doesn't always have to be through court. It can initiate through court, but you can end it out of court. But obviously, the ultimate goal is to just not even get to court. But if it does, many cases resolve. I should also add to that is sometimes the CAFCAS report or the Section 7 report gives very clear recommendations, and it's a different viewpoint, a viewpoint that you may not possess. And that might facilitate you in trying to resolve the issues as well.
Thank you, Manny. Those are some really great top tips. So that's it for this episode of Stowe Talks. Thanks for listening. You can learn more about the varied work Manny does as a barrister on his 4PB profile at 4pb.com. If you would like more information on our podcasts, head over to stowtalks.co.uk and please rate, like, share and review this podcast where you can.